SJC-13098, Commonwealth v. Hakeem, Mushwaalakbar.
Okay, Attorney Levin.
Good morning. May it please the court, Patrick Levin on behalf of Hakeem Mushwaalakbar. Mr. Mushwaalakbar has now been held for more than a year and a half on 2 district court complaints. We're here this morning asking this court for an order for his immediate release on personal recognizance with conditions.
Can you just bring me up to speed? In the Chelsea District Court case, that there was an agreed to motion to modify the bail for $2,000?
Yes, the bail is now $2,000 in Chelsea District Court, and the detention without bail continues out of the Lynn District Court.
Okay, so why is the Chelsea case not moot?
Because our request is for release on personal.
But the motion that was brought before the Chelsea District Court was with your client's agreement?
I'm sorry, the most recent motion for
Yes.
reduction? Yeah. So that was a joint motion for a reduction to $2,000.
Okay, and is there a trial date in Chelsea?
The trial date has been set for June 1st in the Central Division of the BMC.
Okay, and what about the Lynn case? What's the status of that?
There's a trial readiness conference scheduled for May 18th, and I don't know what will happen at that conference.
Okay, thank you.
I don't know my understanding is the trial is not likely to be held in the Lynn District Court, so I'm not sure what the scheduling is going to look like for the spaces that are available in Essex County.
They're doing trials in Essex County, correct?
Yes.
Let me ask you, I've read your brief, of course, Mr. Levin, in the Lebrecht case, the New Jersey case, and there was a case out of the Ninth Circuit as well, Torres, you're probably familiar with. Those cases all deal with the pandemic and this intersection between due process and continued detention. You take it a little further and ask for a beyond the reasonable doubt standard that nobody else has done it. Can you articulate of those series of cases, which factors were we to look at if we were to reopen detention hearings, Mr. Levin, that are applicable given the constellation of factors that are found in the Briggs case and some of the other cases cited in those out-of-state and federal cases?
Yes, Your Honor. So the factors I suggest that are pertinent are the overall length of detention, and also the sort of as a subset of that factor, the length that the detention has extended with the right to speedy trial suspended, the seriousness of the charges and the strength of the evidence against the defendant, the degree of dangerousness and the strength of the evidence of the dangerousness, the possible total length of incarceration.
And I'll cut you off just for a second because I want to clarify that point, Mr. Levin, and you can come back to your list,
Yes, Your
please. On the length of detention, does that borrow from the competency? What was it, 16L? Or I'm blanking on the. You probably know this off the top of your head, but our case law on competency that talks about parole eligibility, does that take that into account as well?
Yes, Your Honor. So the case, the Abbott A case is the Massachusetts case, and of course citing to Jackson versus Indiana. Those are competency cases, and there's a statute in the Commonwealth that requires
That's what I was trying to refer to.
Right. So the statute requiring dismissal at 1/2 of the maximum sentence on the most serious charge. And what Abbott A says is that the due process limitation on pretrial detention is different than, but cannot exceed that limitation.
So you want us to graft that case law into one of your factors?
Not exactly, Your Honor. I don't think that case. I don't think that statute obviously is directly applicable here. But I
was talking more about the concept of, because when we're looking at, if someone is being held on a dangerousness for a relatively minor offense, and the end result is they're not going to do any extra jail time, that certainly weighs. I'm just trying to quantify that, how best to do that.
Yes, Your Honor. And so I'm not asking for a bright line rule of any kind. It's just one factor that needs to be considered in this totality analysis. And it's not only, so the statute that relates to incompetent defendants has to do with sets a bright line relating to the maximum length of the sentence.
And I appreciate we can't get any mathematical rules, and I interrupted you when you were giving me your factors. So other factors, Mr. Levin?
Well, so the factor, not only the potential maximum sentence, but what sentence would likely be imposed upon a conviction, also, of course, is relevant. And
how do we know that?
Well, I think judges are able to make those kinds of judgments based on their experience, Your Honor.
All right, so just based on experience, we figure out what the likely imposed sentence would be.
And certainly the existence and nature of a plea offer also factors into that.
Yeah, let me ask you about that, because I read that, and I forget if it's in Briggs or Fuso, or which case I saw that in. How does that come into play, the plea? Is that a good thing or a bad thing?
So the case that discusses that specifically is the New Jersey case, matter of release of certain pretrial detainees. So there are a couple of different considerations there, but I think in the case before you, it's particularly pertinent that the Commonwealth has made a prosecutorial judgment that the amount of time that would be consonant with justice upon a conviction is less than half of the committed time that he's already served.
So the plea offer relates, in essence, to sentence likely to be imposed.
It relates to that. It also represents a prosecutorial judgment that Mr. Mushwaalakbar could safely be released on conditions right now.
This is the Suffolk case.
In the Suffolk case, yes, Your Honor.
Suffolk, not Essex.
That's right, but just to say that both the Suffolk Superior Court and the Suffolk County District Attorney have concluded that the conditions that are imposed currently on the Chelsea case suffice to protect the victim and the public.
Any other factors, Mr. Levin?
Yes, Your Honor, any specific unfair prejudice to the defendant, and in this case, I would suggest that relates particularly to his knee injury and his inability to obtain physical therapy in jail. And the Christie-Nash pandemic factors, and then the typical bail and 58A factors also will factor into the analysis.
The Ninth Circuit case discusses the fault of the prosecution in this, and then I think the Briggs case discusses the fault of the government as an entity. I certainly know your answer to this one, but with respect to the pandemic in the public safety aspects of 58A, how is the Commonwealth, i.e. the prosecution, at fault at all?
Your Honor, I'm not contending that the Commonwealth is at fault for the pandemic, just that it is their constitutional responsibility to bring defendants to trial. And so the fact that the pandemic has prevented them from doing so is certainly an extenuating factor in the analysis, obviously. Otherwise, almost everyone who's been held this whole time would be entitled to release.
And I know you analogized to Chapter 123, Section 7 and 8 for the beyond the reasonable doubt standard. No other cases have done that. Why is it that we can't ask judges, if we were to adopt your reopening potential, why is it that we should impose a beyond a reasonable doubt standard on the government?
So, Your Honor, you say no other cases.
Well, let me just preface by saying that in all these cases, length of detention alone is never dispositive. And
That's right.
We have lots of cases that well exceed 2 years that are found to satisfy due process, okay? So why should beyond a reasonable doubt be used?
So a couple things on that. First, in terms of the prior case law about the permissibility of extended detention, I do want to just note that those cases involve serious felonies. And the case in front of you obviously also involves a serious felony, but it's being prosecuted in the district court.
No, I appreciate that, and I think what you've asked for, and you haven't asked for any global remedy. You're asking for an individual case-by-case assessment.
Yes, Your Honor.
I appreciate that.
And just to magnify on the point a little bit, which is to say that the federal cases in the bail context that uphold lengthy detentions against due process challenges are organized crime cases, high-level drug trafficking cases, and terrorism cases. So these are really, really serious and complicated crimes to prosecute. Back to the beyond a reasonable doubt standard, my grounding for that request is in the Declaration of Rights and the more emphatic guarantees of substantive liberty rights that are present in Articles 1, 10, and 12. And so the fact that the courts in other jurisdictions don't require such a finding doesn't really speak to the argument that I'm making about the Declaration of Rights. And the cases requiring proof beyond a reasonable doubt in the mental health context in this Commonwealth also depart from the law of other jurisdictions, which requires only clear and convincing evidence in that context.
When we reset the 58 and 57 standards in the CPCS case, the first pandemic case, we didn't change the burden of proof in that. We said that this is a new condition or changed circumstances writ large, and you can re-argue. But in those cases, we didn't reset a standard of proof, correct?
No, that's right, Your Honor.
Those are all the questions I had. Thank you, Mr. Levin.
Thank you. I guess I will just, to go back to sort of where we started out, which is to say that Mr. Mushwaalakbar does have a trial date at the beginning of June on the Chelsea case. And hopefully that will go forward. But that doesn't mitigate the constitutional harm that we're here to address. Our contention, of course, is that the length of his detention already has exceeded due process standards. And so each additional day compounds and magnifies the violation of his fundamental rights. Hopefully the Chelsea case will go forward in June, and hopefully we'll get a trial date soon on the Lynn case, but that's not certain. Just this week, addressing a defendant who wished to delay his evidentiary suppression hearing until it was safe to hold it in person, the court recognized that the continuance that he was asking for was potentially indefinite and acknowledged that for many defendants, the duration of the COVID-19 pandemic may extend far too long to wait for an in-person hearing. Now, relatedly, we all hope that the vaccine rollout represents the beginning of the end for this pandemic, but for the backlog of cases in our trial courts, at best, it represents the end of the beginning. New cases are still being added faster than we're able to take the old cases off the dockets through jury trials. And we're going to be stretching constitutional speedy trial and due process rights to their limits, I fear, for several years to come.
But Mr. Levin, two things. The first one is, well, I'll just ask one of the questions. When it's a 58A, I'm
Yes.
still not sure of why you gave the answer to Justice Wedland about why the Suffolk case isn't moot. But just referring to the 58A, you get to cut the line when you have a 58A, as far as the jury trial.
Yes, that's true, Your Honor. In fact, all defendants who are detained should be at the front of the line.
But the 58A cuts even that, because you have a right to request a trial. That's the whole reason for the Rule 36 incorporation into the 58A. I'm not saying that that's dispositive. I'm just saying that you get to cut the line.
Your Honor, truthfully, I'm not sure what the pertinence of that is.
Well, it's because one of the factors I think you might have mentioned, and one of the factors in New Jersey is the projected length of ongoing detention. It's,
yes.
It's actually in factor number one. So that's why it's it's not a dispositive question, it's just a factor.
Well, Your Honor, I don't want to repeat myself, but we don't know when any of these people are going to be tried. Their detention remains indefinite at this juncture. And the idea that we may be seeing a light at the end of the tunnel here doesn't remedy a violation which is currently ongoing as to my client.
That's all accurate and important. I'm just saying one of the factors is the projected length of continued detention.
Yes, Your Honor. And this, I would suggest this court recognized in Vasquez-Diaz that the projected length of a wait for an in-person hearing remains at this juncture indefinite and unknowable. And this is why it's so important for this court just to clarify at what point this due process analysis kicks in. Because in Luigi, the court just said we're not there yet. We need to know when each defendant is entitled to a hearing and what that hearing entails.
That's what the court said in Torres like a few weeks ago, though, right?
Well, the holding in Torres was, so the thing about the Torres
It
case,
struck me, it had the Luigi language. It basically said, don't do it, but who knows, at some point, there's going to be a due process violation.
so, Your Honor, I don't agree. The thing about Mr. Torres is he received an individualized determination by the trial court, rather than what happened here in this court.
I get you, pandemic related.
Right. So his individual trial judge did that balancing on the federal version of Rule 36B2F and weighed the individual interests of that defendant. It wasn't a systemic decision that all trials are suspended and all pretrial detentions are also indefinitely extended, which is the holding of Luigi. So that the individualized determination is important.
That could help or hurt, right? If it's individualized. 'Cause
Well, Your Honor, my
Luigi-
suggestion is that it must be individualized to comport with due process.
No, I understand your argument.
If there are no more questions, I just want to reiterate my request in the reply.
I'm
brief.
sorry, we don't, well, we got it because you said it the first time.
It's just one sentence.
Is it
Your
something
Honor.
different?
No, it's
not something different?
I just want for on my request for relief, I did want to ask the court to consider issuing, if it's inclined to agree with me as to my client, issuing its order immediately with the opinion to follow.
Very good. Thank you.
Thank you very much.
Okay. Attorney Moriarty.
Good morning. May it please the court, Marina Moriarty on behalf of the Commonwealth. With the court's permission, I will divide my time with ADA Benjamin Shorey representing Suffolk County. I will argue for 10 minutes and he will argue for 5. The continued tolling of the statutory time limits for detention set forth under 276, Section 58A, does not violate due process where the time exclusion remains reasonable in the totality of the circumstances.
Well, that's the point. That's actually the question, right? Isn't that the question? Tell me why it's reasonable at this point in light of the sentence potentially faced by this particular defendant.
With respect to this particular defendant, Your Honor, the Commonwealth's position is that the Luigi reasoning holds with respect to the entirety of the pandemic and that the analysis with respect to the totality of the circumstances still applies and that it is not violative of due process at this point for any defendant. But
Yeah,
with
but
respect
why, I guess? I mean, instead of saying it, why don't you explain why?
Sure. At this point, we are approximately 12 months into detention or 13 months into detention for reasons of COVID, which is far short than the maximum sentence that would be imposed for any of the misdemeanors that are encompassed under Section 58A, and surely well under the maximum for the felonies that are encompassed under 58A.
So what the legal standard says, when the regulatory deterrent is excessive in relation to the underlying goal, that being public safety, and it assumes a punitive character, there's a due process violation, right? What's wrong with having an individualized assessment? Lugie says there's no due process violation now, but let's see. And what counsel suggests is that defendants have the ability to go before a judge and make an individualized case, laying out those factors as to why continued detention may be warranted. If someone certainly, is accused of incredibly violent offenses, and I'm not diminishing what the offense is here, but if there are dangerousness cases and dangerous, as you certainly know, where a judge is saying, no way in the world am I going to let this person out. But there are others that are more on the margins. What's wrong with giving judges the ability, consistent with due process, of having an individualized assessment based on these changed circumstances?
Consistent with procedural due process, Your Honor, the defendants already have the opportunity to file motions to reconsider under the statutory language provided under 58A Section 4. And that is something that this defendant took advantage of several times, filed numerous motions to reconsider based on the factors of dangerousness.
There's a due process. I mean, they filed those but what is suggested is that based on the continued detention, that some of these other factors, because in fairness to the trial judges, they don't have any guidance from us as to what they should be looking at on these changed circumstances during the pandemic.
Well, I do think that this court has offered significant guidance with respect to what constitutes changed circumstances. Luigi specifically said that the length of the detention may be considered under a change in circumstance. The diminution in the Commonwealth evidence may be considered a change in circumstance. So I think that without every single defendant going before a district court or a superior court judge and asking for this due process analysis, which may lead to.
But don't we have a responsibility to issue Luigi 2?
Yes.
All right, so in Luigi 1, we said there's no due process violation at this point, but let's see. Aren't we at the let's see point?
I don't think so, Your Honor. We're in a significantly different position with respect to jury trials than we were a year ago. Jury trials have resumed. Superior Court jury trials of 12 will resume.
Do you have any information for us as to what's happened in Lynn and what's going to happen with this defendant when he has his pretrial hearing?
I am informed, Your Honor, that Lynn District Court trials will be held in the Salem District Court. I am told that jurors will be summoned to Salem District Court 3 days a week, starting either in May or June, and that Salem District Court, Lynn District Court, and Peabody District Court will alternate trials in the Salem District Courthouse. I understand that there is currently a trial readiness list, which essentially is a conference between the prosecutor and defense attorney, and there's a number of cases on that list. I don't have a particular number for Your Honor.
I was going to ask you whether or not you have any information about how many 58A defendants are involved in these proceedings.
I don't, Your Honor. I am told that the majority of the cases that are on this trial readiness list are either gun cases or OUIs where there is a mandatory minimum sentence involved. I am also told by the district court ADAs in this particular case that there has been no plea offer or plea negotiation, and that.
I just want to point out one thing that you said that might leave a misimpression, though. When you were talking about the potential length of sentence, obviously, 13 months doesn't approach the maximum House of Correction sentence, although you're getting there with the parole eligibility. But you said that you implied that felonies require a different analysis. Well, the felony has a maximum 2.5 house correction sentence too, if it's not indicted. And there's no suggestion that this case is going to be presented to the grand jury. So as far as the potential length of sentence goes, the felony analysis is no different than the misdemeanor, right?
That's exactly correct, Your Honor. The only distinction is that in district court, it's 120 days versus superior court, it's 180 days detention pursuant to the statute.
But that doesn't help either because it's 120 days because it's in the district court.
Yes,
I'm just going at the length of the sentence.
I understand, Your Honor. I'm sorry for any confusion. I would just say that with respect to whether every defendant is entitled to an individualized hearing on due process analysis, it's simply unnecessary at this juncture, and the court could, based on where we are today in the pandemic, issue a LUGI 2 and say, we are still not there yet. We may be closer, but given the factors of the resumption of jury trials, the lack of blame to the Commonwealth, the lack of any demonstrative unfair prejudice with respect to particular defendants, that the tolling continues to be reasonable in the circumstances, and if there is, and that, again, motions to reconsider should be freely considered, and
What do we
and
do
those-
with the fact that in this case, it was just summarily denied, seemingly suggesting that the judge felt like LUGI 1 was dispositive?
Your Honor, it was a margin endorsement. I think that you can infer that Judge Brennan just simply agreed with the prior judge's determination on the list of the reasons why this particular defendant in this particular very serious domestic violence case should continue to be held, and that his alleged...
Right, but that didn't include, the prior analysis didn't include the length of the detention of this particular defendant. And in the absence of any writing or any explanation, how do we know that the judge actually took that into consideration?
Judges are presumed to know the law, Your Honor.
Right, but the law right now is LUGI 1.
I agree. It was thoroughly fleshed out in the defendant's motion. So obviously it was before the judge. I think you can infer that he considered the issue. And despite, and I also think that with respect to the sentencing is that he was in the local judges are in the best position to understand whether these sentences are, whether the defendant has been held for longer than would be anticipated were he to be found guilty at trial.
So you agree there's an individual analysis under a flexible due process situation where, let's say, the matter is before the district court judge on March 1st for trial assignment. And the trial assignment date is given, the trial is given for June 2nd. And the defendant's going to wrap up what would be the equivalent of a wrap-up date on June 1st. That at that moment, the due process analysis means that the person has to be released.
Yes, Your Honor.
Can I ask you, I know we're approaching the end of your time, the tolling of these time periods is something that we did, correct? Under our orders. How does the fact that we continue to toll relate to whether or not we give relief? In that if we were to say tomorrow the tolling is over and the clock starts again, that's one thing. While we continue to toll, do you think that we have a responsibility to give this further guidance?
I do. I think this court guidance would promote consistency on a fundamental constitutional issue. I think where this court continues to toll and has said that it's for good cause, and that at this juncture, at least today, we haven't reached the outer bounds of due process. I think that would be very helpful for the lower courts. And I think Judge Hanlon certainly indicated that in her.
We at least have to say that the order relative to excludable delay does not mean that there's not a constitutional analysis that has to take place.
That's true. I think a defendant is always entitled to a constitutional analysis if it's raised.
Okay, thank you very much.
Thank you, Your Honor.
Okay, Attorney Shorey.
Good morning, and may it please the court. Benjamin Shore on behalf of the Commonwealth, representing the Suffolk County District Attorney. I would briefly just address the mootness issue. I do think the bail question out of Suffolk County is moot, and I do think the defendant has failed to show a breadth of this issue that would require the court to address it further. I do think, specifically as it relates to, since the briefs were filed in this case, the new order out of this court, and the fact that the defendant's trial has been scheduled for just a few weeks from now, also weigh in favor of the court finding it moot. I think that finding is appropriate too because the court has recently and clearly addressed the issue, really, and that goes to, there's been some back and forth about the individual analysis under Luigi and Brannigan and the potential of kind of a separate due process individualized analysis. But I think it's important to note that Brannigan lays out a due process requirement that the judges evaluate the length of detention in relation to the likely sentence. And then Luigi cites directly to Brannigan. So I think that...
So how do we know here that the judge actually engaged in that?
Well, so I think the record, unfortunately, is not sufficient to maybe address that issue because the judge's initial finding of dangerousness isn't before this court. There's no transcript of that hearing. And I can tell you that finding, in that hearing, the judge did specifically address the issue of Brannigan, specifically addressed the fact that a high bail was required, even though, based on the defendant's representations, he couldn't post it. But again, unfortunately, that hearing isn't formally before this court.
There was an agreement on bail in this case.
In this case, correct. After the
Assume if the defendant agreed to a bail, it's like a bail the defendant could reach.
Oh, in terms of, yes, the defendant has represented that he could post that $2,000 bill, and that was in the record before the single justice. And then since
So I
that...
don't think we have a Brannigan violation, do we?
No, we don't, Your Honor. But my suggestion is that third requirement is laid out as a due process. That weighing of factors is laid out as a due process requirement in Brannigan, and then that's reiterated in Luigi in a slightly different context. My point is only that I think that individualized analysis is a due process requirement that the lower court justices are required to apply. It's not simply a material change in circumstances independent of due process. If the court doesn't have any particular questions, I would rest on my brief.
Okay, thank you.
Thank you.